Welcome to Assembly Natural Resources. Madam Secretary, please take the roll.
Assemblywoman Anderson. Assemblywoman Bilbray Axelrod. Assemblywoman Brown May. Assemblywoman Considine. Assemblyman DeLong. Assemblywoman Duran. Assemblyman Gurr. Assemblywoman Hanson. Assemblywoman LaRue Hatch. Assemblyman Watts. Assemblyman Urick. Chair Cohen.
And I am present. Please mark Assemblywoman Bilbray Axelrod absent excused. Assemblymember Urick is in another committee. Assemblywoman LaRue Hatch, I'm sorry, she went to fill up her water bottle. I thought she meant she was going to this water bottle, but anyway, so. Right. So anyway, it's good for Water Day. Anyway, again, welcome to everyone for Natural Resources. Welcome to the audience in Carson City. Those joining us, if there's anyone in Las Vegas and in Elko, also those online. Some housekeeping before we get started. Please silence your electronic devices. If you wish to testify, please sign at the table by the door and provide a business card to the committee secretary. For anyone joining online, please be sure to mute your microphone when you're not speaking to minimize any background noise. When testifying, please turn on the microphone and clearly state your name and affiliation, if any. For the record, then turn off the microphone each time you're done speaking. As for handouts, please provide 15 hard copies for members of the public. Electronic copies should have been submitted to the committee manager by noon yesterday. For members of the committee, we expect courtesy and respect in our interactions during the meeting, even if we don't agree with each other's positions. Also, please note, committee members will be using our laptops to view handouts and other documents. Please don't view this as a sign of disrespect or inattention. We will have 2 hearings today. We're going to be going out of order. Our first hearing we will be hearing is Assembly Bill 387, which revises provisions relating to water. So I will open the hearing on Assembly Bill 387, and welcome back, Assemblyman Watts, to your favorite seat in the whole building. Please go ahead when you're ready.
Thank you, Madam Chair, members of the committee, maybe second favorite. For the record, I'm Howard Watts. I have the pleasure of representing District 15, right in the heart of Clark County, and it's my pleasure to present Assembly Bill 387 for your consideration today. This was yet another bill that was recommended by the Joint Interim Standing Committee on Natural Resources and was referred to that committee by the Subcommittee on Public Lands following comments and testimony that was brought forward during a water-focused meeting of the Subcommittee on Public Lands in Boulder City. The kind of genesis of, I'll speak a little bit about the genesis of the bill and how it's gotten to the place it is and the process, and then I will walk through the bill and the mock-up of an amendment which should have been provided to all members and should be available on Nellis, and then I'm glad to stand for any questions. So one of the things that kind of precipitated this bill coming forward was a conversation about recent court decisions that had raised uncertainty about some of the elements of water law, particularly some of the things that were brought into the question were the use of the best available science in decision making by our Division of Water Resources in rendering decisions related to water rights. The ability for the state engineer to manage groundwater basins, which we generally see as separate, dedicated basins with their own perennial yield, and we manage the sustainability of those basins. But increasingly have learned through additional science that particularly when we go into these deeper aquifers in those basins, there are hydrologic connections between them. But the law and the science aren't necessarily aligned. And really the there was concern that the statutes are unclear on the ability to manage particularly conflicts that occur because of usage in hydrologically connected but separate groundwater basins. And then the third issue is the conjunctive management of groundwater and surface water, which simply put is something that we now, again, know from science. We've known this for a long time. Springs are an expression of groundwater coming to the surface. Those springs can then flow into creeks and flow into rivers. So there's a connection between that groundwater and that surface water. Also, surface water, rivers and streams, those stream beds can sink down, even though that water is flowing, and penetrate into the groundwater system that's connected to it. So, while the particulars may vary depending on the geology, we know that there's a connection between groundwater and surface water, but we have surface water rights and we have groundwater rights. We have surface water law, we have groundwater law, and those have generally, at least within this state, been seen as fairly separate things. The state has taken steps to try and recognize and address some of those issues and those conflicts as they've been demonstrated, particularly in recent times. And again, as these things are litigated, which water policy constantly is in this state, some of those things have come into question. And so what we sought to do through AB 387 is to provide some clarity and some guidance in how the state can and should manage those conflicts moving forward. These are really complex issues that really impact the entirety of water law and water administration in this state. And these are issues that have come before the legislature before. And so at issue was, and I've been involved in some of these debates since before I had the honor of joining this body. Those debates have often been resolved with putting some language in legislative declaration encouraging the state engineer to consider the best available science in rendering decisions concerning the available surface and underground sources of water in Nevada, or the legislature declaring that the state should manage conjunctively the appropriation, use, and administration of all waters of the state, regardless of the source of the water. And the reason those things made it into legislative declaration is because we couldn't agree on a clear statutory framework or language for how to do those things. So there was a recognition that those things are important, but a legislative declaration isn't the same as statutory authorization for what the state can or should do, or how they should go about doing it. And so AB 387 is an attempt to try and clarify some of those issues and establish a real, true policy for the state in addressing these issues. And the overall intent of what we've tried to do is make that application as narrow as possible. So first of all, with the conjunctive management of surface and groundwater, there's a little bit of this bill that potentially touches on that, but ultimately, really, when it comes to setting some clear conjunctive management policy, it's just at this time something that haven't been able to reach some clear consensus with all the many stakeholders on. So what this bill really focuses on are the other two concepts: the use of the best available science, which this bill seeks to, as it currently stands, seeks to address by taking the language of that legislative declaration, striking it out, and putting it in statute explicitly with the state engineer shall at the beginning. So again, taking it out of the legislature thinks it would be great if to the state engineer shall administer water law in this way. And then, seeking to provide some clarity on managing hydrologically connected groundwater basins And there's been a lot of different ideas, a lot of different proposals. There's been action taken by the state to essentially manage interconnected basins as a group. What, in a lot of conversations, we determined, or I determined, was the best way to kind of move forward in providing some of this clarity is to make it as narrow as possible. And so what this does is it doesn't touch really the organization of basins or the organization, to potentially draw those lines or to designate groups of basins to be managed. What it does is tries its best to acknowledge that because of those connections, conflicts can arise. And when they do, we should manage those conflicts the same way we would if they occur within a single groundwater basin. So we were really trying to preserve prior appropriation, beneficial use, all the other tenets of water law, but acknowledge that those don't just apply within a groundwater basin, that there can be scenarios where somebody in an adjoining basin, that their use might be up gradient of another user in a hydrologically connected basin, and that might impair that other standing right, and that in addressing those issues, we should follow the same water law process that we have if that was to occur within a single basin. So that at a high level is what we're trying to work towards. I've tried to reach out and share the overall goals with everyone that's interested in water policy in the state. I think you see most of them sitting behind me right now. Had a lot of conversations, gotten a lot of feedback, and again, these things are tricky. If we could have all figured it out and gotten on the same page, we wouldn't be having this bill hearing today. And so there's still disagreement. I don't think we're going to reach something that everybody agrees on. My goal is to get something that addresses as many of the concerns as possible and is a step towards trying to reconcile the hydrologic realities that we face with the state's policy to make good decisions moving forward. And those conversations are ongoing. I just want to note. So we've got a proposed mock-up here. With apologies to the chair and staff, there will be more amendments forthcoming. Probably we are not going to have this figured out even with whatever amendment gets brought forward for a work session. These conversations are going to continue, and I just want to be completely upfront about that, but really appreciate everyone who is engaged in this, that believes that we need to take action towards this, and even if we're not on the same page yet, has really been extremely helpful in providing feedback and suggestions to try and hone this in. And so this is what I feel like is the closest that we are at this point in time. So with that, I'd like to walk you briefly through the bill and the amendment. So Section 2 of the bill references groundwater basin, and Section 8, I believe, of the bill defines groundwater basin. Those are proposed to be removed in the amendment. Again, I feel that that starts to get into this idea of designating entire groups of basins and reshuffling kind of the priority with them. And from the conversations that I've had, I feel that it is more appropriate to really focus this in on identifying and resolving specific conflicts when they can be identified and demonstrated. So the amendment proposes to remove those sections of the bill. Section 3 is, and Section 5 are what I just referenced in terms, and so members can see that. In Section 5, we are striking out the legislative declaration related to encouraging the state engineer to use the best available science. And Section 3 takes that exact language and says the state engineer shall consider the best available science, and puts that into statute so that it is clear direction and authority for the state engineer to do so. Let's see, moving forward. So section 6 is where we are starting to try and include the incorporation of hydrologic connection. And so this, again, is a section of law that discusses conflict with existing rights. And so in the original bill, there was some proposed language to be added. In the amendment, we've tried to simplify that a little bit more. So instead of noting the existing rights of holders of permits, claimants of vested rights, et cetera, it's, when there is a conflict with existing rights from any hydrologically connected surface water or groundwater, or with protectable interests in existing domestic wells. So again, we're just trying to add into this section of law a recognition that there may be a conflict with an existing use or right that stems from hydrologically connected sources that may not be within the same groundwater basin. Moving on. So section 8 was what I referenced with the adding the definition of groundwater basin or basin. Oh yeah, and section 7, so there was some language related to basin that then was being moved to section 8. So again, we're still working on some of this, but trying to not go and completely redefine groundwater basins or hydrologic basins at this time. And so section 8 is proposed to be deleted. Section 9 had some conforming language. That would also be deleted because the changes to Section 8 are going to be removed. Section 10, one thing I want to point out is the existing, what would now be subsection 2 in Section 10. I just want to draw your attention to that language around all underground waters within the boundaries of this state belong to the public and subject to all existing rights to the use thereof, and then this is adding a reference to the subsection 1, are subject to appropriation for beneficial use only under the laws of this state relating to the appropriation and use of water and not otherwise. And so subsection 1 is seeking to an extent, mirror, build upon, and clarify that by noting that any appropriation, and I will say that it's my intent that it's not only new appropriations of water, but all appropriations of water, of underground waters. And then within the boundaries of the state is proposed to be stricken because we have groundwater basins that cross state lines. And so we want to kind of try and recognize that as we're looking at policy moving forward. So any appropriation of underground waters is subject to all existing rights to the use of the source thereof. And then, again, trying to clean up the language a little bit related to points of diversion, just saying that regardless of where the source is, any appropriation is subject to all existing rights. Putting that into the closest thing to plain English, if you want to appropriate and use water, that's going to be subject to water law and all existing rights. So if it conflicts with an existing usage or right, that has to be dealt with through our existing water law, regardless of what the source is, if they're connected. So it doesn't matter if it's in the same basin or if they're in different basins. If there's a connection and that connection can be demonstrated, you have to deal with it the same way you would if it was within the same groundwater basin. And that's what the rest of the language is, noting that if the state engineer finds a hydrologic connection sufficient, and that is, so not just a connection, but a connection sufficient to cause a conflict with those existing rights. Moving forward through the bill. The next major section here is section 13 and subsection 3. In determining whether there is unappropriated water in an affected area, the state engineer shall make this finding in accordance with NRS 533.370. We took some of that language out because it is duplicative of existing NRS. And again, that's basically, we're trying to create a point back to similarly say, in determining if there's unappropriated water, we've got to recognize if there's some connections that may be leading to essentially kind of some double counting. So we don't want to go and say that there may be unappropriated water when it turns out that that's actually is within kind of a hydrologic system that may already be accounted for. But again, that would have to be demonstrated through a process with the existing processes with the state engineer. And then the rest of the bill is conforming language. So I'm sure I'm going to have many questions. That concludes my presentation. And thank you for your time and consideration.
Thank you. I appreciate all the work that went into this and that you're still continuing to work on it with many stakeholders. Can you give us, with the understanding that you're still working on this, so the concern is if you've got two rights holders and they kind of, now there could be conflict. So can you give us an idea, tell us the story. What's going to happen now if there's conflict?
Thank you for that. Howard Watts for the record, Madam Chair. It's a great question. And again, this is tough. Water is scientifically very complex, and between every region, every basin has its own quirks, and the difficulty is trying to reconcile that very specific science with also having a policy, particularly at a statewide level, that provides a framework for how these matters are handled and provides some degree of certainty to folks. And that's at a really high level, that's one of the things that we're struggling with, is trying to have some clarity and certainty in policy. So if the policy is too broad and provides too much flexibility, it creates tremendous uncertainty. And water rights, while the waters are belong to the people of the state and are managed, the rights to use those waters are a type of property right, and they have value to those that hold them. And so that's without getting into an extremely specific case, that's kind of the struggle that we're going through, is trying to balance that, but also recognize that you can have something on paper, but if it doesn't align with the science, it's going to create a lot of problems. And we're in the driest state in the nation in terms of precipitation, and so we're trying to come up with a framework that makes sure that we manage these resources in the best way possible. To answer your question a little bit more specifically, here's the rub with the policy, is that these are essentially, in situations where this occurs, where conflicts occur, for the most part, we're looking at kind of a zero-sum game. There's going to be winners and there's going to be losers. And if somebody has what they thought was a more senior right, but because of different hydrological connections, it's demonstrated that, this is one of the big issues with conjunctive management policy. If a surface water right is being impaired, in general, those are all senior to groundwater rights. And so you have two options. One, create some sort of mechanism to assist the groundwater user, which basically is fiddling with the foundations of water law. Or B, you have to curtail the use of the groundwater that's impairing the surface water, and that's somebody's that has value to that person. That's their livelihood. And so when you're looking at a situation where the science says somebody's got to lose, it's a really tough issue. And so that at a high level is kind of what we're dealing with. And what I've tried to do is do do my best to take the most narrow and focused approach to that possible. So instead of, for example, with combining basins, which has been proposed, we didn't get very far down the line on some of those processes, but essentially you're taking Basin A that has its set of water rights users and priority dates, and Basin B that has the same. And if you combine them, because everyone's, because of the hydrological connection, now all those priority dates get intermingled, and folks that felt fairly confident in their rights before, maybe less so now. And so instead of doing that, what we're really trying to focus it in is, okay, identify and demonstrate a conflict, and that this right or this usage is going to impair another, and then handle that the same way you would handle it in an existing basin, because we have a really robust framework for handling that if it's in the same groundwater basin. But once we start to get into these areas of hydrological connection, our statutes are less clear. I hope that provides some clarity.
Thank you for that. I have a question from Assemblymember DeLong.
Thank you, Madam Chair. I might actually have two, if that's okay. Thanks for the presentation. I think these edits, which I just was reading while you did the presentation, so hopefully I've caught them all. I think deals with an issue, and you brought it up, that's the super basin concept, which I don't think was ready for prime time, given a number of issues, particularly a takings issue. So I think that makes a lot of sense, and the way you describe the potential conflicts, and it's primarily, in my mind, going to be existing surface water rights versus a junior groundwater right. And the way that's likely going to be demonstrated is through modeling, which gets to the best available science language you've put in. And I would hope that in the additional discussions you have, that the term best available science is actually flushed out, such that we're actually not creating this broad term that's subject to interpretation by state engineers as they go forward, that we as legislators establish that policy. So
Thank you for that concern. If I may address that briefly
Please do.
before you go forward. Thank you, Assemblyman Howard Watts, for the record. I really appreciate that. I do think that best available science is one of the main areas that continued discussions are happening around. I and some of those behind me all share PTSD from trying to define terms when it comes to water law. It's really tricky, and again, the situations can vary so much from between basin to basin and region to region. But I do understand some of the questions around how does that get defined, how does that get sorted out. But yeah, I mean, environmental soundness is in state statute. It's not defined. There's been a lot of conversations and debates about how you define terms. So again, I just want to acknowledge that those conversations are ongoing, and I do understand that. But when you try and define them, it also gets very, very tricky. And when we looked at the proposed definition for groundwater basins, one of the reasons I didn't want to go down that path. So I'm not saying no, but I just want to say I appreciate that concern, and that's definitely one of the things that we're going to continue to talk about, but also acknowledge the challenges when it comes to some of those things.
yeah, thank you for that. I guess the one thing I would add, I touched on it, and that is just moving forward with this concept of the potential for takings claims is something we all need to keep in mind. And that's a tough one.
Thank you for that, Howard Watts, for the record. It is tough, but again, it's trying to figure out, we have to manage, all the waters as a public resource. And if we're in a situation where we're not sustainable, everyone loses. And so the goal here is, and again, this is the tricky thing about water rights, because while folks feel, particularly with senior rights, very certain in them, first of all, senior rights also have to be put to beneficial use. And so there are multiple aspects to water law besides the date attached to that. That water has to be put to beneficial use on an ongoing basis. So, and again, if we already have a general foundation of, hey, if there's conflicts or it turns out, whoops, we goofed it, and because if we do it right, we should only give out rights to water that can be sustainably used. But there's been some quirks and some missteps along the way, and curtailment and other things are the backstop of, okay, and particularly with surface water that can be quite variable in its supply. It's okay, well, if the water's not there, then we start cutting off those who are junior. And so the water right is only guaranteed up to a point. And so I guess the perspective I'm bringing forward is we need to have a holistic approach to viewing that, and not pretend that that doesn't apply if there's surface groundwater connection. And I would just say, to your other point, I do think there's also the potential for conflicts to arise between hydrologically connected groundwater basins as well. And again, the idea is that you'd go back to some of those same things. So like we discussed with surface water, seniority, and other things, that's how you start to manage a conflict if it can be demonstrated between two uses in separate groundwater basins, if it's demonstrated that there's a hydrological connection. And the last thing I'd like to say, so I mentioned that there's been court decisions, and there's folks that have a stake in some of those decisions here. And really, this is not aimed at influencing the outcome of a court decision. It's not even aimed at a specific region. It's recognizing some of these things that I feel have been brought up as very valid points and in need of clarification in our law, so that we have a better understanding of how the state and different stakeholders proceed in addressing these issues moving forward.
Thank you for that. Just wanted to follow up on some of the things you just said about potential conflicts between basins that have been interpreted to be hydrologically connected. Based on these amendments, do you think that that's something the state engineer could implement?
Howard Watts, for the record, yes, that's the intent. Thank you.
And thank you, Assemblymember Watson. I really appreciate that you're coming at this, acknowledging to us that this is a big problem and this is not an easy solution, and that even today you're not saying, it's going to be great, we're fine, there's no problem, we'll just connect the basins and we'll all be great. So I have a question, but I think it's more for legal. So if we end up with rights holders in conflict, will we end up with like an eminent domain case? Like, how will that proceed when we talk about having winners and losers and moving forward with someone ending up getting the right and being able to use the water versus someone who now becomes a more junior user, or because it's our water, the state's water, do they lose the right and that's it? Or would you like to go take a few days and research that, because that was...
Erin Sturdivant, Legislative Council Bureau. That is a question that I'm not sure I can answer in a broad sense, because my understanding of the bill is that it's sort of prospectively amending the statute to require the state engineer to consider best available science going forward. And so all water permits are subject to existing rights already, and you're not guaranteed that water if there is no water. So we believe it's facially defensible from the perspective of takings and eminent domain and all that, but obviously on an as-applied basis, we can't predict what could happen.
Okay, thank you. All right. Okay. Assemblymember LaRue Hatch.
Thank you, Chair, and thank you for taking on this critical issue. I think we all agree that water is our most precious resource, and it is diminishing thanks to climate change and everything else. And I think it's really essential that we are updating our statutes, some of which have been around since the very beginning, to recognize the modern science and then the modern issues that are going on. I really liked your quote of, if we don't manage this property properly, we all lose out, right? And so we need to make sure we're protecting it for everyone. My question is on these hydrologically connected basins. Do you know how large some of them can extend, or how many basins we know are hydrologically connected based on what we've discovered?
Thank you for that question, Assemblywoman. Howard Watts for the record. I don't think we fully know the extent of those things. Again, there is ongoing modeling and other science seeking to demonstrate and prove out some of those things. And in some of the work that I've done in the past, we've examined, and I should say I've been involved. I'm not a hydrologist. But I've worked with organizations that have done hydrology, looking at interconnections between multiple basins. And I don't remember the exact number, but, less than 10, but more than 3 basins, in eastern Nevada, and again, including basins that actually straddle the Nevada-Utah border. One of the big issues that has come up, there actually was the designation of a kind of super basin in the apex area, and I forget, it was a few basins that got combined there. And then one of the things that has been a major issue that I'm sure you're going to hear about in some of the testimony as well has been what's known as the Lower White River Flow System, which is in southern Nevada. I think, depending on who you ask, involves, I think, five or six basins, groundwater basins. And again, I'm doing this all off of recollection, so if I speak in error, I'm off by 1 or 2, please forgive me. And there's been a demonstration of connection across those different basins. And then to complicate matters even further, there's also a discharge of surface water expressing itself into Muddy Springs. Muddy Springs supplies the Muddy River. Muddy River flows into the Colorado River. There's endangered species involved. It is a very complex system where all of these things are at play. So sometimes you're talking about surface water and groundwater. Sometimes you're talking about interconnected groundwater basins primarily. Lower White River Flow System gives you all of those things. So those are a couple of examples. But again, I think, and you'll probably hear from some folks, that the science is still ongoing. Some people disagree with some of the models and findings that have been put out there so far. So it's hard to give a definitive answer.
Assemblymember Hanson.
Thank you, Madam Chair. Thank you for being here. You're never afraid to take on a big one. And hey, I shared my water with you today. He's so good at conserving water that I walked by his office and his plants needed a drink, and I had a pitcher of water, and I literally watered his plant. So, it didn't have to be mandated. I did it anyway. So, actually, in regards to the best available science in rendering decisions, who's going to determine the best available science? If we thought prior appropriations was controversial or maybe a sticky wicket at times, I think trying to determine who's deciding best available science could get us in that same kind of trouble. But you could elaborate, please.
My pleasure. Thank you for the question. Howard Watts for the record. So this, as it stands in this current draft, the state engineer shall consider. So basically, the different stakeholders and participants in any proceeding before the state engineer's office will provide science. The state engineer may look at what else is out there that's already kind of public domain and been provided, and then take all of that into consideration. And to make it really simple, the state engineer would decide up front. I want to note that, again, if it's contentious, which most water issues are, it's going to be litigated. And so the state engineer will decide it first, then a judicial court will decide, potentially a Supreme Court will decide. Maybe things will get remanded back to the state engineer, and I'm sure, they're very familiar with some of these processes that go around and around and around. But the state engineer would be the first entity to make that decision. But again, everyone will be able to plead their case there, and then there is judicial review of all those decisions. So that's how I envision those things being discussed and sorted out.
Assemblymember LaRue Hatch, you had a second question?
Thank you, Chair, and thank you for allowing me a second question. So there's obviously a lot of questions about best available science. Can you just speak to, and I know the state engineer is here, so you can probably phone a friend if you need to, but can you just speak to what they are using when you're saying that they are referring to the science? Do they have scientists on staff? Are they just doing a quick Google search? What are they doing when they are looking into this science?
Thank you for that question, Assemblywoman. Howard Watts for the record. And I don't think I need to phone a friend quite yet. I'm sure that the state engineer will come up probably in neutral to just be able to provide some additional clarification and maybe answer additional questions that you all may have. I think it's a whole range of things. So Assemblyman DeLong referenced models. And so that, again, you're taking certain data points, drilling wells, doing some pumping, and trying to determine what impacts there might be, doing water chemistry analysis as well to try and understand, where water may be flowing and what some of those connections may be. So again, you can do kind of water level monitoring. You can do pump tests and use those and then you apply a model to that to try and understand things at a higher level. One of the things that I will say for some of the folks that don't follow these things as closely is, the baseline science that kind of figured out the yield for a basin were done by the USGS. They were called recon studies, and they happened about 50 years ago. And so that's kind of what we're going on. And again, it's also just important to understand how some of the science of accessing water even has changed, as well as the science of understanding it. At first, we had the water that you could see, and we would divert off of that in order to meet the needs. Then we were able to start harnessing groundwater, and a lot of our basins are developed really based on topo maps, and we have got all these mountainous regions and these valleys, and you're able to kind of look at that and see, okay, well, here's where water would come down from, and here's the bowl where it sits, and that works really well for shallower aquifers known as like basin fill. But then we found out that there's also deeper aquifers, that there's, again, some of that water is filtering down, some of that water is thousands of years old. And then that's when it really gets zany, because the geology does not necessarily mirror what's going on in that topography. So I hope that somewhat answered your question about some of the science and some of the complexity involved.
May I just follow up just briefly? So to confirm then, they're actually going out into the field and they're confirming these things. They're not just relying on information provided by others.
Thank you for that. Howard Watts for the record. So again, there can be different models developed, but there has to be inputs into that, and those inputs have to be gathered into the field. So I will say there's a mix of in the field data points, and then figuring out different interpretations of that data and what it means. And there are efforts underway to update some of the baseline science that we use within the state to make some of those decisions, and potentially updating some of that science just on its own could have impacts to the current kind of water rights that exist currently.
Okay, and we have another question from Assemblymember Hanson.
Thank you, Chair, for another chance. I think we'll have dueling this issue out. Regarding the best available science, I guess, I mean, it's not like there's a bunch of angst with it in Section 3, but I just guess I'm going to ask, why do we feel we have to say shall consider the best available science? Was the state engineer not considering the best available science before? And so I'm just wondering what the need is to even put that in a statute.
That's a wonderful question. Thank you, Assemblywoman. Howard Watts for the record. And first of all, I forgot to thank you for watering my plants. I'm very bad at that, so I appreciate you. I think there's two parts to your question. One is, why even have that? What would the alternative be? And that's one of the reasons why I wanted to address this, because I'm very concerned if it's not clear that the state should be making decisions based on science. I'm extremely concerned about what the alternative is. I'm a political science major. I want decisions to be based on actual sciences, not political sciences. It's also tough. I want to say, folks that have a lot of financial resources can pay for lots of modeling and things to try and demonstrate a point. And so that's a factor of concern in figuring out, is the best available science whoever has the most money? But on the flip side, if we're not making decisions based on science, is it whoever has the most money or the most connections? And so that's one of the reasons why I think it's important to have this really clear. As to why we're moving this around and having that be part of the debate, there was a court decision that said, that's legislative declaration, that's not statute. Nothing in actual NRS that says what the state shall do or is authorized to do says anything about using science. And so there was a court case and it's being appealed, but it flagged that, hey, legislative declaration is not statute. There is nothing that says that the state should make decisions based on the best science. And so that's what led me to explore options to make that a little bit more clear.
Madam Chair, I promise, my very last follow-up to that, just a comment.
Okay, but just to be clear, we shouldn't put this all on the Assembly member because this actually came out of the interim committee. So the interim committee met and studied this issue, and this was the terminology that the interim committee decided that was appropriate to use.
Exactly. And just because a lot has transpired since then, I get what you're saying about things can be political and in modeling, but also so can science. We've lived through that in the last few years, that science can be manipulated or politicized. And so that was my main thing, is just that I agree. We need to base things on science, but unfortunately, even science has become political. So it's not a guarantee, right, that we're going to get the best science. And that, I guess, is just, unfortunately, the nature of the beast of the days that we live in. So I appreciate what you're trying to get to. I appreciate what we tried to study in public lands and in the interim. And I know you're trying to get to a solution. And so I'll be quiet so we can hear from all those that have a lot to enlighten us with. Thank you.
Okay, so with that, ready to move on to support? No other question? Okay, so what we're going to do is, if there's anyone in Elko, which I don't think there is, anyone in Las Vegas who's in support, please start filling up the chairs, all one of you, if you are in support. In Carson City, if you are in support, please fill in the chairs as you go. And then also, so just so we're all on the same page, we're going to go for 2 minutes at a time. We will be timed. We'll have half an hour in support, half an hour in opposition, half an hour in neutral. Neutral is you are just providing information. It is not support light. It is not, we really like Assemblymember Watts and don't want to say something nasty about his bill and hope to get to somewhere. It is just providing evidence. Also, if you really like the bill, but you're not quite there yet, if you're not quite there yet with the mock-up that we have right now, that is opposition. Please, you're free to let us know that you're 99% there. You're going to keep working with Assemblymember Watts. But technically, under the rules of this committee, that is opposition, so please proceed that way. So please go ahead, Doctor.
Hello, I'm Laurel Saito, and I'm the Nevada Water Strategy Director for the Nevada chapter of the Nature Conservancy. And we do really thank Assemblyman Watts for working with many people to bring this bill forward and for working on this complex but important topic. We are speaking in support of this bill. Nevada's groundwater aquifers provide drinking water and economic benefits for people, and also support groundwater-dependent ecosystems that rely on groundwater to maintain their ecological structure and function. Most of Nevada's rivers are groundwater dependent, originating as springs or groundwater seeps with additional inputs from groundwater along their length. Because of this connectivity of groundwater to surface water, it is possible for groundwater use in one hydrographic area, or administrative groundwater unit, to affect surface water flows in another hydrographic area. AB 387 addresses this connectivity between surface water and groundwater by clarifying that the state engineer must consider whether applications for water rights in a specific hydrographic area would impact existing water rights or be detrimental to the public interest in another hydrographic area. The bill also obligates the state engineer to consider the best available science and water decisions in the state. So these changes will enable the state engineer to make science-informed decisions about Nevada's important water resources. We appreciate the efforts of Assemblyman Watts and his work with stakeholders to move the administration of water resources in a more sustainable direction, and we're ready to work with him and other stakeholders on the bill to make it more effective. Thank you for allowing me to testify.
Thank you. Seeing no one else in support in Carson City, BPS, please go to the phones.
If you would like to testify in support of Assembly Bill 387, please press *9 now. Chair, there are no callers choosing to testify at this time.
Okay, thank you. So with that, we will go to opposition. If there's anyone in Elko or Las Vegas in opposition, please make yourself known. So we're going to start in Carson City, but we won't forget about you in Las Vegas. But please go ahead and take a seat in Las Vegas. And in Carson City, please fill in the chairs as you go.
Thank you, Chair Cohen, members of the committee, Patrick Donnelly with the Center for Biological Diversity. Following the rules of this committee, we optimistically oppose this bill. We support the intent of this bill. We've been working diligently with stakeholders on finding something that's workable for everybody. We aren't there yet. There's still wordsmithing to be done, but I would say the group is well on its way. The bill that you have in front of you in the amendment is the result of unprecedented collaboration. Pitched battles have been fought in this building over this very topic in previous sessions, including 2017 and 2019. However, we're in a very different place now. Assemblyman Watts has provided a vehicle for this collaboration, and a diverse group of interests has been working diligently to find something that'll work. So it's very different from previous, quite adversarial encounters around this topic. And so there's a desire to continue moving forward and to keep working on the bill. You know, I will say this is not about a single case or a single place. You know, I think the case has helped illuminate where there's a need for clarification, but I think our stance is the language we see in front of us right now is clarification of existing authorities. And that these authorities do exist and actually have been a part of the practice of Nevada water law, but there's question as to whether those authorities are readily available. And so the intent of this bill, as I understand it, is to clarify those authorities rather than a dramatic rewrite of Nevada water law. But if we do get there, if this bill does pass, it really will be a breakthrough moment, I think, in the evolution of Nevada water law, because it will be a chance for many stakeholders to come together and say this modest clarification, this modest change is actually acceptable, which has generally been a blocked point in the past. So, and I would just finally add, this bill is not just like for the benefit of the environment. There will be lots of winners and losers as this type of thing gets implemented. So we won't be winning all the time, but it is moving towards science-based management of water. Thank you.
Madam Chair, members of the committee, Kyle Roerink with the Great Basin Water Network. We're in a similar situation as Mr. Donnelly. We oppose the bill, but we support a lot of what's inside it, and we want to thank Assemblyman Watts for his work on this, and we're grateful for the committee for giving us an opportunity to speak here today. Water knows no borders. There are lines on maps, and then there are hydraulic realities. And I think what we're trying to address in this bill are the hydraulic realities of how water flows through basins. Again, these lines on basins were drawn up 50 years ago, and now we know a little bit more, and we know how the water moves. And so I think, we're here to address conflicts and to try and limit conflicts in the future. And I think giving us a shot at doing this, continuing the wordsmithing, will be really valuable for the long run in the state's management. I think as it relates to the issue of best available science, I think everybody's always going to be suing each other over that. I've seen USGS models with plus or minus 35% margins of error, and that's the gold standard. And so there's always going to be a fight about, what is happening underground. These are strange mosaics that we can't see. And so I think, but again, this all comes back to clarity, and that's what we're advocating for in this. So thank you very much for your time.
Madam Chair, members of the committee, my name is Christina Erling, and I'm Vice President of Government Affairs for Nevada Gold Mines. We appreciate the opportunity to come before the committee and appreciate the work of Assemblyman Watts on the issue of conjunctive water management. As the bill is currently written, Nevada Gold Mines is in opposition to AB 387. However, we stand ready to continue working with the committee on this issue. We are willing to support the concept of conjunctive management if it is properly implemented. The legal distinction between separate management of groundwater versus surface water has been applied for over a century. This means that a wholesale revision to the Nevada water law on this distinction must be done carefully to avoid harming the state's economy and creating unconstitutional taking. AB 387 currently does not contemplate which party bears the burden of proof for demonstrating the existence of conflicts between water right permit holders, or how the state engineer is expected to arrive at best available science. Additionally, existing elements of Nevada water law, including the limitations on the definition of beneficial use, means the state engineer will be limited in the implementation of conjunctive management in such a way as to cause unnecessary harm. Other states have implemented conjunctive management with some success, but only because they worked for many years to understand the issues for their particular water basins and designed their state laws to include alternative measures to meet the needs of all water users, including voluntary conservation, aquifer recharge, and water banking systems, to name a few. Only then, with the proper tools developed, can conjunctive management be implemented without harming water users and the state's economy. Nevada lacks these tools, and this bill does not address the shortcoming, which leaves the state engineer with curtailment as a primary tool. AB 387 as it stands is a one-size-fits-all approach to a state with hydrographic basins that differ widely. We encourage the committee to step back to continue the conversation with stakeholders on this important concept, because the success of this effort depends on careful design and implementation of the laws and regulation. Thank you.
Thank you, Madam Chair, members of the committee. For the record, my name is Kyle Davis, today on behalf of the Nevada Mining Association. We appreciate all of the work that has gone into this from Assemblyman Watts, from the Interim Committee on Natural Resources, and many people in this room that have been working on this, both before the session started and throughout the session, right up until yesterday, and we'll continue to work on it. And we appreciate that we've been a part of many of these conversations, and appreciate that that we will hopefully be able to continue these conversations and to get somewhere that's productive for the state. As so often is the case with water law in Nevada, just as you think you've solved one problem, you realize that you potentially are creating a new problem that you need to deal with, and that's why these things are so complicated to figure out. Nevada Mining Association supports the comments that you just heard from Ms. Erling with Nevada Gold Mines and many of the points that were raised. But we look forward to continuing to work with Assemblyman Watts and everybody in this room to address these challenges. And thank you for your time today.
Thank you, Madam Chair, members of the committee. Andy Belanger with the Southern Nevada Water Authority. We support AB 387 and want this legislature to work and do the hard work to pass this bill this session. We recognize it's not there yet, and we know there's more time that is needed in order to move it forward. But I can tell you, having been here when the best available science language was put into the statute in this very room nearly 20 years ago, clarity is key. You know, make the laws clear. Let everyone know what the rules are so that everyone knows what we're doing. What we've done over the last 20 years is half measures sometimes and compromises that have made it hard for courts to understand what the legislature wants to do. So best available science has been the standard that the state engineer thought he was doing for the last 20 years. If you want to know how he's going to implement it, it's going to be pretty similar to what he's done for the last 20 years. It's time to make it have the force of law. It's time to make sure that we understand what a basin is, whether we can manage them hydrologically connected basins together or apart. But if they're hydrologically connected, make sure the law says that. Make sure it says it, because if the science is there, the law needs to reflect the science. Because otherwise you're just going to get into a situation where the law is not going to keep up with it. So I recognize we're not there yet. I know there's more to do, but we appreciate so much Assemblyman Watts' work on this issue. It needs to get done, and it needs to get done this session. Thank you.
Good afternoon, Chair Cohen and members of the committee. My name is Bryn Gibson. I'm here representing Coyote Springs. We're here in opposition to the bill, even as we understand and appreciate the intent behind the bill. Candidly, and to be honest, our basins in Nevada are over-appropriated. We simply do not and will not have enough water to satisfy everybody's needs today or tomorrow. We get that, client gets that. The problem here is that the cure of the bill doesn't actually solve the pressing problem. Instead, it upends over 100 years of well-settled Nevada water law, adding tremendous legal uncertainty on top of an existing resource uncertainty. Changing long-standing rules will not ease our water problems or fix the issue of over-appropriated basins. It will merely reallocate water winners while breaking bedrock law. First in time means first in right, and this has been a hallmark of Western water law. This is the rule of priority. This bill will radically reshuffle the line. It will not shorten the line. On the contrary, decades of settled expectations will be upset in a moment. And planning for the future, when we need solid planning more than anything, will be even harder. How can anyone negotiate going forward if they are worried about the rules constantly changing? As the sponsors of the bill mentioned, there is ongoing litigation. I won't get into that, but I would note that for the record, and I thank you for your time, and I look forward to working with all of you and the bill sponsor to tackle these difficult issues. Thank you.
Mr. Gibson, I do have to say, I don't think the rules changing once in 100 years or so is the rules constantly changing. I think we have a job to do, and it's something for us to consider, and I appreciate your testimony, but I don't think there are any other laws in this building that haven't been changed in the last 100 years. So it is something that we are going to consider and move forward with and do what we think is best for the state. And when I say move forward with, I don't mean that that was not me saying that this bill is necessarily moving forward. That was me saying we are moving forward with the process. But thank you.
Madam Chair and members of the committee, for the record, my name is Jeff Fontaine. I am the Executive Director of the Central Nevada Regional Water Authority and also the Humboldt River Basin Water Authority. And like the others, we appreciate the committee's interest and Assemblyman Watts' leadership on AB 387. And like many others here today, we have been participating in the ongoing discussions with other stakeholders. In keeping with the chair's rules and protocol, we are testifying in opposition to the bill, and the conceptual amendment is presented. The amendment certainly gets us a lot closer to agreement, but as has been discussed here this afternoon, Nevada water law is very complex, and essentially any change can have a significant impact and also an unintended consequence. AB 387 presents, I think, some pretty unique challenges in terms of understanding how those impacts and predicting consequences as it relates to at least our priorities of protecting water rights and rural water interests. We support the consideration of hydrologically connected surface water and groundwater in managing the waters of this state, and also the use of best available science, and has been discussed here as well. Best available science is sort of a difficult term to define, but I can tell you that at least from what I have researched, there are some basic standards and parameters that we think would provide or have merit in getting us to a better understanding of what that means, and also, I think more importantly, to avoid future disagreements and litigation. So we're committed to advancing good water policy for Nevada, and certainly committed to working with Assemblyman Watts and others on this bill. Thank you.
Good afternoon, Chair Cohen and Vice Chair Anderson and committee members. My name is Emilia Cargill, and I'm here on behalf of Coyote Spring Investment. This is a 5-point summary of the letter that we previously submitted. 1, existing statutory structure. In 1968, the state engineer and the government indexed 232 hydrographic basins in Nevada. Since then, the legislature has addressed water usage basin by basin basis. AB 387 gives the state engineer the authority to ignore basin by basin management that it has been implementing for the past 50 years. There are thousands of water right holders who have relied on the basin by basin process in adherence to the prior appropriation doctrine of first in time, first in right. Number 2, history and justifiable reliance. Under the current statutory scheme, no water right holder would expect that its water rights would be curtailed in favor of a water right holder in a different hydrographic basin. AB 387 would reject decades of water holders' rights, expectations, and entitlements, and in effect does so retroactively. Nevada water law statutes are based on prior appropriation, and AB 387 obliterates prior appropriation. Number 3, Coyote Springs. Coyote Springs' master plan involvement in southern Nevada is a perfect example of the injustice in AB 387. In reliance on its senior water rights in Basin 210, Coyote Springs has spent in excess of $300 million installing infrastructure, wells, water treatment, sewer treatment. It did so relying on the law. Number 4, the term basin. AB 387 redefines the term basin, and we support the strike of Section 8 from the amended bill because we believe that was overbroad. Also, the procedure by which the state engineer determines the hydrologic connection is neither defined nor described, and we're concerned it will be a fodder for future litigation. Number 5, the victims of AB 387. AB 387 is an attempt to get legislative permission to do what the legislature and judiciary have previously prohibited. The victims of AB 387 are the Nevada companies, farmers, ranchers, and individuals who've purchased water rights with the good faith belief that this legislative body would not take from them that which they've already paid for and beneficially
And Ms.
used.
Cargill, we're at 2 minutes.
I'm
so
done.
Thank you.
Thank you.
Thank you, Madam Chair, members of the committee. I'm Jake Tibbetts, and I'm the Natural Resources Manager for Eureka County. As various interests started discussing and making proposals under the BDR that became this bill, Eureka County held that we should wait for clarity from the Supreme Court on many of the matters of this bill currently in front of the court, so that we can collectively be more focused and surgical in any legislation. However, we recognize that others do not believe the same, and we have, in good faith, been part of the process to find common ground or a spot where we would not oppose. We believe a lot of progress has been made and the conversations have been productive. AB 387 is very improved from some of the previous proposals that we've seen, and specifically with the amendment. Some of the outstanding points we're committed to continue to work through, and you've heard on some of those, but we wish to see the best available science better boxed in and clear on what it means. We will note that there is a change in the language from the current declaration in the statute by removing the term availability, and we're trying to weigh what that may mean moving forward. We agree that the state engineer should recognize hydrologically connected waters, but only to address clearly identifiable or demonstrated conflicts. We remain concerned with how priority of rights would be addressed without first identifying conflicts with some reasonable certainty, and we remain committed to work with the bill proponents and other interests as we move forward. So thank you.
Good afternoon, Madam Chair, committee members. For the record, I'm Steve Walker. I'm representing Lyon County. Lyon County was opposed to the bill as written, but with the removal of Section 8 and amendment, their position, like the existing bill, is quite dynamic. By the way, as an old guy who has worked extensively in Nevada water issues, the 50-year-old document frequently referenced today, called the Reconnaissance Report, were actually quite good.
For the record, I'm Doug Busselman. I'm the Executive Vice President of Nevada Farm Bureau. I want to also start out by expressing my appreciation for being able to be part of the collaboration that's been going on in developing this bill, working with Assemblyman Watts, the state engineer, and my fellow collaborators. Nevada Farm Bureau is opposed to AB 387. Nevada Farm Bureau policy states, "We oppose the combining of established water basins and believe that management of individual basins lead to a more precise stewardship of water resources. The ability to see and measure what is happening under the ground is highly subjective. We see that basins are valuable as boundary references for decision-making. Inflows to a basin can be measured and are estimated. Outflows from a basin can be measured and are estimated. The science applies to the basin and allocations approved based on that basin science. We're also concerned about using computer-generated models and broad brush applications of data to address site-specific decisions. Our contention is if there are connections, there may be different degrees, and there may not be happening in all of the locations within that basin. Thank you for your consideration."
Good evening, Jennifer Lazovich, here today on behalf of Republic Services. Republic owns Apex Landfill in southern Nevada, which is where all the solid waste goes from our franchise, solid waste in Henderson, City of Las Vegas, Clark County. And so we have water rights to operate that landfill. It's critical, and we are in current active litigation on issues that are raised in this bill with the state engineer. That litigation has now been appealed by the state engineer's office, and so for those reasons, we remain opposed to the bill. Thank you.
Good afternoon. My name's Karen Peterson. I'm an attorney in private practice here in Carson City, and I've represented Vidler Water Company for many years on water right matters in Nevada. And Vidler has groundwater rights and surface water rights in northern Nevada and in southern Nevada. Vidler is opposed to AB 387 for the many reasons set forth in Ms. Timian Palmer's letter previously sent to the committee. But my testimony in summary is, and I'm trying to adopt, I just saw the mock-up today during the hearing, and so I'm trying to adapt some of my comments to that. But we still have concerns about Section 10. I heard Assemblyman Watts say that the intent of Section 10 would be to connect basins that were hydrologically connected. And we have a concern about that because that's exactly what happened in southern Nevada, and Vidler was part of that group. Vidler and Lincoln County Water District own water rights in Cane Springs. The state engineer broadly stated that there was a hydrologic connection between 7 basins, and that at the end broadly stated that there were conflicts and made decisions, supposedly based on the best available science, that eliminated 38,000 acre-feet of water from being pumped. And that's the concern, that this language is maybe still too loose, and those kinds of decisions could still be made. Past state engineer orders show 2 different state engineers can have very different views of hydraulic connection and can have very different views of conflicts. Thus, how those terms may be interpreted under AB 387 create more uncertainty. Under Sections 3 and 10, the state engineer can define a water resource by hydraulic connection using the undefined term best available science and allow pumping that is causing impacts to continue as an existing right another word used in the statute, and require junior rights not causing impacts to stop pumping. There doesn't appear to have been any analysis of the impact of AB 387 on other sections of Nevada water law. Under existing water law, the state engineer can't curtail pumping in Cane Springs. There's no water right issues or problems with Cane Springs or water source problems in Cane Springs. But under AB 387, if he can still connect basins, I'm not sure if he still can, but if he can still connect basins.
And ma'am, we're over 2 minutes, if you can wrap it up.
Okay, thank you. He can take action to curtail water rights in Cane Springs when he can't do that now under existing law because there aren't any problems in Cane Springs. And we do have some more points to make, and I'll just submit some written testimony. Thank you.
And I appreciate you making changes on the fly as you reviewed the amendment.
Thank you.
Please go ahead.
Thank you. For the record, I'm Mike Reese. I am the Vice Chair of the Lincoln County Water District, and I'm here in opposition of AB 387. I will be the first one to say ditto. We've heard a lot of testimony, and we're nodding our head like yes. Our big concerns is, number one, is the priority. A lot of people have invested a lot of money and stuff into something and planned communities, stuff based on their senior water rights, and that now is in jeopardy, and that is part of the detriment of the bill as it sits right now. I don't know that you can clean that up or not, but as of right now, we are strongly opposed to AB 387. Thank you.
Good afternoon, Madam Chair and members of the committee. My name is Leo Drozdoff, and our firm represents Truckee Meadows Water Authority as well as Nevada Cogen. I'm going to focus my comments from Tumwa, and Richard will speak to Nevada Cogen. We do extend our thanks to the interim committee and Assemblyman Watts for what many have described to be true, which is the unprecedented amount of communication and working collaboratively. We still feel that the bill and its amendment are short when it comes to process and due process. I think these are very weighty issues, and the ability to rely on something in statute to, whether it was a hearing or something else, that people with water rights would have the knowledge that there would be a place to bring their concerns and it would be tight and rigorous, is still probably an area of the bill and the amendment that we think needs work. But we'll continue to work with the group, with the many stakeholders, and appreciate your time.
Madam Chair, members of the committee, Richard Perkins for the record, representing Nevada Cogeneration. Number one. Number two, we've had a number of conversations with Assemblyman Watts and other stakeholders, and to echo what Mr. Drozdoff said, continue to want to work through these issues. I think you'd have to have been asleep for the last 30 years to not understand that we're in a water crisis throughout this state and need to find some solutions. We have over-appropriated basins. We have all sorts of other challenges, in spite of the weather of the last few months, that has brought us the precipitation that we've so sorely needed. But looking forward to working with all the stakeholders and following the leadership of Assemblyman Watts to find these solutions. Thank you.
Okay, sir in Las Vegas, thank you for being patient. Please go ahead.
Thank you, Madam Chair. For the record, my name is Bevan Lister, and I'm just representing myself, and that's really important because I'm nobody. For background, I'm a farmer by choice, so I use water. I'm an engineer by training, so I know a little bit about water systems. And I'm a water well contractor and licensed driller in the state of Nevada, so I deal with water on a first-hand basis every day. I own water rights and manage water in 2 counties in 2 separate basins here in the state of Nevada. I stand in opposition to AB 387. First, I'm not sure what we're trying to accomplish. If the purpose of the bill is to make water law less functional, open the state engineer to more lawsuits to lose, and diminish the value and certainty of held water rights, then this bill would be a success. If the purpose is to give direction to the $5 phrase conjunctive management, then the offering of more subjective or undefinable terms is simply just a sidestep and serves no justice in addressing the questions surrounding the $5 term. Nevada has a simple and powerful system of water allocation using the principle of prior appropriation. The Office of State Engineer is tasked with administering the allocation of that water under the law. It's unfortunate that for some time that office has been unable or unwilling to create the necessary record to support the actions that they take. The best available science is always site-specific. We have long trusted and assumed that the state engineer is using the best knowledge of water and systems to set a perennial yield for each basin and allocating accordingly. The concept of connections between sources has always been a point of interest in the setting of perennial yields. The science needs to be documented to substantiate the decision. Let's not change the law with nebulous terms that lead to more litigation. You cannot ever write enough laws to avoid all conflicts. That is why we have a court system, and that court system needs laws that it can stand on, not lose its balance over.
And sir,
As a
we're
farmer, I
over
need
2 minutes if you can wrap up, but feel free to submit your testimony in writing.
Thank you very much.
Thank you, sir. And seeing no one else in opposition in Las Vegas or in Elko, if we can go to the phones, please, BPS.
If you would like to testify in opposition of AB 387, please press star 9 now to take your place in the queue. Caller, you are unmuted and you may begin.
Oh, thank you. First off, I'd like to, this is Robert Kochi with the Water Strategy Group. I've been doing water rights and administration and filing for water rights for about 40 years. First, I'd like to thank Assemblyman Watts for the effort that he's put into this and how open his office has been to all of us. He's finally trying to do something, and I really appreciate that instead of been kicking the can down the road for 20 plus years on this. I agree 100% with what Andy Belanger said, and I want to piggyback on that. While we are in opposition to the bill, it's, we're just still got a few sticking points and stuff. I fully support the definition of what they're doing with best available science. I was with the state engineer's office for 30 plus years. Regardless of what you heard, I've never seen a time where we did not try to use the best available science that's there. And best available science can be anything. We talked about models, but it also talks about actual data. That's even better than best available science. Every water right's been issued subject to existing rights, and we have 60 years of water rights that were issued before the basins were ever created. They deserve to be protected. And there is hydrologic connectivity. Just because we have a basin boundary drawn on the map doesn't mean that the sources are not connected. And they have to be regulated and protect existing rights, which are often senior rights because of that. And we really oppose anything being done about waiting for the Supreme Court to make the decision. I think every legislator in the building will recognize that it's their job to make the law. I appreciate Assemblyman Watts moving forward with that and look forward to working with them in the future. Thank you.
Sir, can you restate your name?
Robert Kochi, C-O-A-C-H-E.
Thank you very much. BPS, do we have anyone else on the phone in opposition?
There are no other callers at this time.
All right, with that, we will go to neutral in Carson City. Please go ahead.
Good afternoon, Adam Sullivan, Nevada State Engineer. I'm testifying neutral on this bill. This bill, along with the amendment that was introduced by Assemblyman Watts, it adds clarity in water law in a way that we believe is consistent with what water law already directs the state engineer to do. But there is some ambiguity, and this is an opportunity, I think, to clear that up. I think it's very much consistent and protective of the prior appropriation doctrine. I also believe that it helps align water law with the hydrologic science, and this is really essential for realistically protecting water security into the future for our dry state. Thank you.
Chris Mahana for the record. I'm a licensed civil engineer, water rights surveyor practicing in the state for 37 years. I've been involved in legislative committee meetings through NDWR and CNRWA on this bill. We really appreciate Assemblyman Watts' efforts on this. It's sorely needed. I echo what the state engineer just said. We're testifying neutral on behalf of Churchill County and the Truckee-Carson Irrigation District, large water users on the bottom end of the Truckee and Carson rivers. I won't take any more of your time. I've submitted detailed written comments that are on Nellis. Thank you very much.
Madam Chair, for the record, Ed James with the Carson Water Subconservancy District. We have not taken any position on this bill. We do hope that the state engineer uses the best science, not old science, but we understand the conflicts and issues with it, and we're willing to work forward to continue to try to resolve these issues to protect our resources. Thank you.
Will Adler with Silver State Government Relations, representing Pyramid Lake Paiute Tribe. I would like to ditto the comments by Ed James there. Same approach, but we'd like to thank Assemblyman Watts for bringing this bill forward. Water law is complex and has a lot of issues. Pyramid Lake was opposed to this assembly bill, but the corrections or the amended version of the bill has a correction to Section 6 and Section 13, and that has brought Pyramid Lake into neutral at this time. Thank you very much.
Okay, seeing no one in Las Vegas or Elko, BPS, if we can go to the phones, please.
Chair, the line is open and working, but there are no additional callers at this time.
Thank you. Assemblymember Watts, would you like to catch up Assemblymember Urich? Just kidding.
No, thank you, Madam Chair.
Okay, please go ahead.
I'm glad these are recorded. You can watch them on above 1 time speed, just as a pro tip. Thank you, Madam Chair, members of the committee. Again, Howard Watts for the record. I really appreciate all the testimony that was provided today, and appreciate how many people have acknowledged that there are some issues that are in need of clarity and have really worked in good faith to try and get something done. And I am committed to keep working to try and get us to that place, because I do feel that it is important. And again, really appreciate all those who have been involved in providing constructive feedback, and sincerely hope we get to that place. I do just want to note a couple of things based on some of the testimony that came up. You heard concern about impacts to priority, but you also then heard other folks say that this upholds priority, and I just want to again reiterate from my perspective that this is not meant to throw out priority or beneficial use or any of the other core tenets of water law. I hear some of the concerns as well. I know that throughout NRS we have many references to the hearing process the state engineer goes through, because anytime there's a conversation about a proposal, we want to make sure that it goes through the same transparent hearing process and that there's judicial review. And I just want to make clear on the record that the goal of this and the intent of this is to, again, add clarity and not have anything take place outside of those processes. So this is just providing some clarity to kind of the boundaries with which the state engineer goes through their decision-making processes. All of this would have to go through hearings that have all the notice requirements that are in place. All of those decisions would be subject to judicial review. So I just want to make that extremely clear for the record. And finally, I understand the concerns that are brought up by folks that are involved in litigation. And again, I just want to say that while some of the points that were raised in recent court decisions, I think, brought up the importance of looking back at our statutes and looking back at some of, frankly, the compromises that we've made because we couldn't reach an agreement on anything before, and having a conversation and reevaluating that and making sure that we have a strong framework. I feel that it's our responsibility to not delegate all of these decisions to courts to interpret, and that we need, as a legislature, to provide a policy foundation that, knowing full well that in these contentious issues, they're going to be litigated as well. But it's our responsibility to provide a framework for how decisions go through that process. And if we wait until all litigation on a water law topic is resolved before we try and address it in this body, we'll never do anything on water law ever again, in my opinion. So thank you all for your time and consideration. Thanks for everyone that's been involved in the process.
Thank you. And with that, we will close the hearing on Assembly Bill 387 and invite Assemblymember DeLong to make his way down to the table. And then, just so we're clear, Assemblymember Urick and Assemblymember Duran have been in committee hearings straight since 1:30. So, yeah, so I was just teasing the Assemblymember. He was working hard, and Assemblymember Watts is off to present another bill in another committee in the Senate. So we're getting to that part of session. Okay, and I'll let people exit the room.
Don't take it personally.
Okay. Do you want to get one? Okay, so with that, we're going to open up the hearing on Assembly Bill 191, which revises provisions relating to water conservation, and welcome Assemblymember DeLong to proceed.
Good afternoon, Madam Chair, members of the Assembly Natural Resource Committee. I'm Assemblyman Rich DeLong. I represent District 26, which is located in southern Reno and southwestern Washoe County, and I will endeavor to do as well as my colleague just did. I'm here today to introduce Assembly Bill 191. I have submitted a friendly amendment to the committee, which you should have, and I know that it has been posted in Nellis. I will be presenting based on that amendment. The bill in general seeks to provide regulatory relief to very small municipal and quasi-municipal water suppliers. And I'd like to start with a little bit of background information. Currently, as outlined in NRS 540.121 through 151, a supplier of water is required to develop and maintain a plan for water conservation. That plan includes methods of public education to increase awareness of the limited water supply in the state and encourage reductions in the size of lawns and the need for the use of arid and semi-arid plants. Identify specific conservation measures to meet the needs of the service area. Develop the management of water to identify and reduce water losses in water supply, inaccuracies in water meters, and high pressure in water supply. The goals for acceptable water loss in water supply shall include an infrastructure water loss index, water audit data validity score, operational basic parent losses, operational basic real losses, and economic level of water loss. The plan must also analyze how the supplier of water will progress towards the goal of acceptable water loss by manage water to increase reuse, have a contingency plan for drought conditions, a schedule for implementation of the plan, a plan for installing water meters, establishing standards for water efficiency for new development, establish a tiered rate structure, and establish watering restrictions. In addition, the plan must have measures to evaluate the efficiency of the plan and the effectiveness of the plan. For those conservation measures, an estimate of the amount of water that will be conserved per year. So as you can see, the requirements for a water conservation plan are extensive. In addition, it appears the intent of the statute is to address water conservation for water suppliers with a multitude of service connections, some of which are measured in the thousands of connections. However, in the state, we have a number of very small water suppliers, such as the Dyer Elementary School in rural Nevada, the Animal Ark, which is an animal conservation facility north of Reno, or the Spencer W. Kimball Scout Reservation southwest of Las Vegas. And each of these have less than 15 connections. These facilities only provide water for their operations. To require this type of water conservation planning for these types of locations that are throughout the state is unnecessary, and they should be relieved of that burden. So with that, what I'd like to do is walk through the bill and the amendment, and it's much more straightforward than the last bill that we heard. In subsection 3, we've added some limitations on those water suppliers of water that are other public and private entities. They have to be more than 15 service connections and have to serve year-round residents of the system. That's the extent of the change, and I'm available for any questions.
Thank you. Okay, so I was a little distracted by some of the noise in the hall before I got the door shut. So can you explain again, the service connection, those service connections, are those always going to be for different locations? Or can that be one facility with multiple?
Service connections?
Connections,
Yes,
yeah.
you could have as few as one, as many as 14, and still be subject to this amendment.
Okay. And then was this something, I'm not sure if you're aware and I can find out, but was this a requirement that we added recently in the legislature?
I actually don't have that information. I know that the state engineer's here, and my guess is they're going to come up and speak in neutral. They might be able to provide those data.
Okay, thank you. I have a question from Vice Chair Anderson.
Thank you, and thank you for bringing forward the language. Actually, I have two questions. The first has to do with the chapter itself, not necessarily language that you're bringing forward, but it had me thinking. And so I wanted to, when you spoke about the education area around it, has there been any, or have you considered any sort of discussion about what was passed last session where we were able to educate individuals about how much water usage or abuse, my opinion, is used for areas that are right around traffic areas, in particular where there's grass and everything like that. And so I'm bringing this up to see if you would be open for an amendment or if there was a way for us possibly to do this discussion offline. Because at this time, that language is only available for the largest county in our, or the most populous county in our state.
Thank you for that question, Assemblyman DeLong. For the record, I'd be glad to have further discussions with you about that.
Thank you so much for letting me bring that into the room. The second question has to do with the decision to take away on the amendment 2B and that does the usage matter anymore, or is that, was the decision to remove the use of 3 acre-feet based upon other information?
Thank you again for the question, Assemblyman DeLong. For the record, the bill was originally drafted such that it was the restriction on the need to supply a water conservation plan was based on the amount of water used. In further discussions, including with the state engineer, it seemed more appropriate to use service connections as the limiting factor.
Thanks, okay. But you could have a supplier with one service connection that's using a lot of water that we need to get this information on, correct? I mean, we're kind of presuming that if you don't have that many connections, that you're not using that much water.
Thank you for the question, Assemblyman DeLong, for the record. Yes, they could be using a certain amount of water, but it would be limited by their water right. So just as an example, for most of these, the 3 examples I gave, their use is in the neighborhood of single-digit acre-feet per year. So a very small amount of water. And as an example, the Dyer Elementary School has a water right of just over 6 acre-feet.
Okay, sorry, just looking through this. All right, so I have a question from Assemblymember LaRue Hatch.
Thank you, Madam Chair, and thank you for answering our questions and for bringing this. So my first question is, under this current language, could these facilities then be allowed to ignore all conservation measures? And for example, if they are in Clark where they're not allowed to have certain turf or recreational lawns or whatever the language was, could they now completely ignore that and do whatever they want with their water?
Thank you for the question, Assemblyman DeLong. This regulatory relief would limit their need to have a plan for water conservation. They would still be subject, in my mind, particularly in Clark County, to any land use restrictions that the county or the city may have on them.
And then may I have a second question, Chair? Okay, my second question is, I understand what you're talking about, these extensive plans, and these facilities may not need to do these extensive plans that other much larger entities are doing. But in the interest of really focusing and ensuring we're only achieving what you want to achieve, could we not simply excuse them from that one requirement without changing their entire category within the chapter?
Thank you for the question, Assemblyman DeLong. I'd be glad to have further discussions with you about how to change the current friendly amendment language.
I do have.
Assemblymember Considine.
Thank you, Madam Chair. And originally I was looking at this and I was thinking, okay, so there's your original bill before the amendment was 3 acre-feet, which is, I think, close to 1 million gallons. And then you just mentioned 6 acre-feet for one, which is close to 2 million gallons. So my question is, taking out the 3 acre-feet limit, I guess I just need some more information on what close to 2 million gallons could be used for if it's just one user or one area.
So thank you for the question, Assemblyman DeLong. The example I gave was for the Dyer Elementary School, which is a school in Dyer, Nevada in Fish Lake Valley. They're using water for toilets, probably some landscaping as well as sinks. And 1 or 2 million gallons in in the scheme of water use is over a year is actually a relatively as a very small amount of water.
Assemblymember Hanson?
Thank you, Madam Chair. Thank you for being here. When we talk about how many acre feet perhaps the Dyer Elementary School has, doesn't mean they use all 6 acre feet, means they're allotted that, right? They don't go over that per se.
Thank you for the question, Assemblyman DeLong. Yes, that's correct.
And then, I'm sorry, just one follow-up real quick. You mentioned on the record in your opening remarks 3 examples in the state, but I was taking some notes. It's not just those 3. It's not that small of a bill. It applies to others, but you just named 3 on the record, right?
Thank you very much for that question. Yeah, Assemblyman DeLong, there are actually about 350 suppliers of water that would fall into this category.
So I'm going to presume everyone's a good actor, but these are small entities. But if there are, let's say, leaks or things like that to where they're losing water that they don't even realize they're losing, that type of thing, would the conservation plan help them figure that out? Or is it just really causing them to waste time and effort and spin their wheels when it's just not really benefiting saving water for the state?
Thank you very much for the question, Assemblyman DeLong. For the record, I think given that these are such small users, another example is a 7-Eleven in, I think it's in Elko. They have so few uses of water that they're likely going to see where they have a leak. It's not like a supplier of water that has 3,000 service connections and hundreds of miles of pipe that they're trying to manage. So I think given the size of these users, I would think the plan has limited use in them watching for leaks in their pipe.
Okay, and then would it make it, and I appreciate that, and then as we get up to the 14 and under, would that make any difference? So if we had one that was 14 and under, I mean, I guess I think we want to save water where we can, and we want to conserve where we can, but we certainly don't want to make more work for anyone that doesn't need it.
Thank you for the question, Assemblyman DeLong. As I said to the other Assemblywoman, I'm more than willing, if we want to look at trying to add some conservation measures in and revising this language, I'm more than interested in working with the committee on that.
Okay, thank you for that. Okay, seeing no other questions, then unless you have anything else, we'll move on to support.
Thank you.
Okay, I don't see anyone in Elko or Las Vegas, so let's have people in Carson City fill in the chairs. Okay, seeing no one in Carson City, BPS, if we can go to the phones.
Chair, the line is open and working, but there are no callers at this time.
Okay, thank you. And if we have, seeing no one in Elko or Las Vegas for opposition, do we have anyone in Carson City for opposition?
Thank you, Madam Chair. Patrick Donnelly. In this comment, I'm representing myself. We are in supportive opposition of this bill. We support, I believe the original version was a little closer with the 3 acre-foot limit. The chair raised a very good issue about the potential for large amounts of use on the 15 service connections. So I think having that acre-foot limit is the best approach. But the reason I'm supporting this bill on a personal level, I live in a small community of 200 people, and I'm the T2 water treatment systems operator for our small community water supply. The regulatory burden on tiny water facilities is huge, and typically these are run by volunteers. These are run by small communities that have limited ability to respond to large regulatory burdens. I think we use just a couple acre feet a year at our community water supply, and we would definitely know if there was a leak because it's such a small amount of water. And meanwhile, relieving that regulatory burden on small community water supplies really does make a difference in them being able to provide for their communities. So while we oppose a word or two here, we do support the intent of this bill. Thank you.
Thank you. Seeing no one else for opposition in Carson City, we will go to the phones.
Chair, there are no callers at this time.
Okay, anyone for neutral seeing no one in Elko or Las Vegas, we will go to Carson City. Welcome back, Administrator. Please go ahead.
Good evening, Adam Sullivan, Nevada State Engineer for the record. I'm testifying neutral on this bill, and the reason I'm testifying neutral is our staff are the ones who receive and review these plans and work with those who have to prepare the plans and assure that people who are required to do so actually put it together in the way that it's prescribed. Water conservation plans are an important and valuable tool for small water providers to be water conscious. As discussed already, there is a common awareness, I think, that there's a number of very small users that get swept up in this and are developing plans that don't provide a whole lot of practical use. We agree that the proposed amendment to 15 connections is an appropriate cutoff. That would be consistent with a standard that NDEP uses for small water providers, and which would help in the administration of determining who this applies to. As discussed, there is an awareness, I think, among small water users. There's an awareness and other opportunities for water conservation that are in place and are realistic and practical, that this wouldn't threaten. Some other examples that are seasonal campgrounds that get swept into this, that have to provide, put together plans that don't end up being particularly practical, or like a small restaurant with a gas station. That's another example, and we have a lot of those. And so another element here is that by not requiring those really small entities to put together a plan, it makes it more efficient for our staff to be able to spend their time working on larger water providers, where there really are important and valuable elements to having a robust water conservation plan. So if you have any questions about the statistics or the content of the plan, our staff who work on these plans are here this evening, and I'm sure they'd be happy to come up and help me answer any detailed questions if you have them.
I have a question, but I think you might be able to answer it, and we can call up your staff if needed. So for your office not having to review this, would that be helpful? I know we've talked before about your office and kind of the burdens on your office right now, and we're getting some nods. So yes, would you say this would be helpful, that your office's time would be better spent doing other work?
Yes, very much so.
Okay, thank you, I appreciate that. Committee, do we have any questions? Okay, seeing none, all right, thank you very much. Okay, and BPS, if we can go to the phones for neutral?
Chair, there are no callers at this time.
Okay, thank you. Assemblymember, would you like to make some final remarks?
Yes, Assemblymember DeLong. For the record, just like to say thank you very much to the committee for the hearing and the questions, and looking forward to working with those that had suggestions on potential amendments. Thank you again.
Thank you. With that, I will bring Assembly Bill 191 to a close, and we will open up for public comment. Is there anyone in Carson City for public comment? Seeing none, seeing no one in Elko or Las Vegas. BPS, if we can go to the phones?
Chair, the line is open and working, but there are no callers at this time.
Okay, committee, any comments? Okay, seeing none. With that, we are adjourned. Thank you, everyone.
So I think Assemblymember Yurick should be given a